usually goes through, I mean, what does an applicant have to, well, expect in that 6 months that you're processing an application?
If I may summarize, an application, when we receive applications, we examine it for substantive purposes. Like we compare it with a database to see if the mark is similar to any of the registered marks. So usually the substantive process, it will the maximum length of time for that would be 1 month, where we find whatever grounds for refusal or any other grounds for rejection of the
It's a thorough
mark.
examination.
It's a
Do you
thorough
just rely on
examination.
your database, or what if it's a like Chinese mark or a foreign sounding mark, like it's written in French or foreign language? I mean, how do you go about examining that kind of work?
If the mark consists of foreign characters, then we ask the applicant to give the transliteration and translation of the foreign characters or foreign words.
Transliteration meaning the per syllable breakdown of the
Yes,
trademark.
yes, and then the translation, the English meaning of those foreign characters or words.
How do you consider that? I mean, trademarks can be just words, or it can be, I mean, there could be a design, a
Yes.
symbol. Do you examine all of those elements when the trademark application comes to you?
Yes, yes. We look at it holistically and also determine the dominant portions of the mark. So that's what we do in comparing a mark subject of an application to a mark that has been filed earlier or registered. So we look at it holistically and
Also per
using
element.
also the dominancy test.
Also per element. But there are instances when brands are used anyway, even without registration. I mean, for example, if I start using a brand, let's call it Crown, for example, Crown for soft drinks, but I haven't registered it and I've been in business for 5 years, is it okay to register it a little late?
Yes,
I mean,
it's definitely okay. Actually, trademark registration is not mandatory.
it's not mandatory.
It's not mandatory, but it's really, we really advise the owners of the mark to register their marks before it's too late, before somebody else copies the mark. So that would be too late for you. So you have to go to litigation to recover the mark, to regain ownership.
So that's more expensive.
More
and,
expensive,
yes, more
tedious,
tedious, yes.
burdensome. Yeah.
So they have to register it ahead of time. But
Yes.
personally, I don't think many people are familiar, or many business owners are familiar, that there is such a thing as trademark registration. I mean, do we need more awareness about?
Yes, that's
about
why we
this?
have this program to help us campaign, especially encourage the business sector to register their trademarks with our office.
How is it different? Because business owners go through a lot of permits that they have to obtain. They have to go to the barangay, sanitation, local government. They also have to go to DTI for business name, and the SEC, the Securities and Exchange Commission, for their corporate name. How is that different? I mean, particularly SEC and DTI compared to trademarks, which is, as you said, not mandatory.
They're similar in a way, because we're DTI, SEC, we refer to our own databases. We look
You're
at
linked? You're linked together?
No, we're
Not
at the
necessarily.
moment we are not yet linked. But similar, if you file an application for business name, the DTI representative also has to look at their database if there's already a similar business name registered in their office. In the same way, the SEC also looks at their database to determine if a corporate name or partnership name has already been registered with their office. Yes.
Yeah, but is it possible to, usually you go to the SEC for the corporate name, XYZ Corporation,
Yes.
and then you go to the DTI, you give a sole proprietor or a partnership,
Yes.
you give the names of the partners. But with trademarks, with the IPO, you file the name of the product or service that
Yes.
you're using. Is it possible that people register as a corporate name trademarks? I mean, for example, what if I name my corporation Disney Corporation? Is that possible? Can that happen given our system?
Well, business names or trade names are protected even without registration. So, for example, and we are a party to the Paris Convention, and Paris Convention protects trade names as well. So, Disney may run after that entity that registers this new corporation here in the Philippines.
So, I mean, an owner of a trademark, whether or not he or she is registered with the IPO, always has remedies to prevent others from unauthorized use,
Yes,
as you
yes.
said. But of course, the prevention is better than cure. So register it first, register your brand first, so that no one can copy it, no one can distort it, or
Yes.
register it ahead of you and give you a headache, right?
Yes. And let me remind our business men. No. They may file a trademark application with our office even if they're not yet using the mark. So for example, they thought of a very distinctive trademark, very attractive trademark, and they want to use this later on for, let's say, clothing line or for a restaurant business. So they may already file a trademark application with our office, even if they're not yet into business, as long as they use the mark within 3 years from the filing date of the application. So
Okay.
you don't really have to be in business before you can file a trademark application.
Okay, but earlier you were saying that if it's a misspelling and for the same class of goods, it will not be allowed.
Yes, for example, you file a trademark application for ball pen, spelled as BOLPEN.
It's a misspelling of
Misspelling,
ball pen
yes.
for
and
goods that are pens.
For ball pen, also for
yeah.
pens. So that is still considered as generic.
So it cannot be
It cannot
registered
be.
as a trademark. So
Right.
if, for example, I have a product and I call it kape, and it's
Yes.
coffee, I
Yes.
cannot register that
Yes.
because it's generic. So you
Right.
cannot use common nouns as your trademark.
Yes.
Attorney Jen, what other tips will you give our business owners so that they can formulate their brands and make sure that they can own it and protect it as trademarks?
Well, first, I would suggest that they look up our database so that they can compare their trademarks with already existing
Trademark.
registered marks in our database. They just log on at our website, IPOPHL.gov.ph, and click the link for trademark search, and they just type the name of their brand, and then all the hits referring to that name will come out. And so they can determine if there's already a similar brand name or logo registered with IPO.
From what I'm getting, that's one of the most common grounds for rejection, whether there is a previous mark already registered. So that's one of the most common grounds for rejection. But do they need lawyers to assist them in IPO when filing for a trademark? Or is this something that you think they can do by themselves, just fill out the form and send the payment to the IPO?
Well, I have to apologize to our compañeros and compañeras. Actually, they don't really, businessmen or our clients, as we call them, really don't need lawyers to prosecute, to process their trademark applications. It's only when issues are raised, like there is a confusingly similar mark, that may be.
That's when you might need legal assistance.
Yes.
When you cannot register your application.
Yes. Yes, but if they conducted a research first, they search our database and there's no similar mark, then they can process their application even without the assistance of lawyers.
Yeah, so I mean, all they have to do is go do that search just to guide them in making their
Yes.
brand, right?
And plus, they can call our office anytime and ask for our IPSO officers, those who are in the
IP satellite.
information desk, and they can ask anything about trademark application, and
You're
we're-
welcome. You will assist them
Yes, definitely.
when they call the office.
Definitely.
Are there? I mean, where is IPO, and do you have offices in the provinces, or are you nationwide, or just
Okay,
here?
our office is located along Buendia, near Makati Avenue. So we're based in Makati, although we're transferring in a few months to McKinley Hill in Taguig.
In Taguig.
But we also have our satellite offices in key cities of the country. Like we have our office in Cebu, we have one in Davao, in Legazpi, in Iloilo, in
Lawag.
in
Baguio.
Pampanga.
Pampanga, Angeles.
Yes. So we have satellite offices spread out nationwide.
Yes, and we're opening one. I mean, the IPO is opening another branch in Cagayan de Oro by the end of this month.
Yes.
So are these linked to the DTI in the provinces? And can the DTI assist our brand owners in filing their registration?
Yes, we work hand in hand with our DTI counterparts, especially the regional operations group. And we have IP advocates in not only in the key cities that I mentioned, but nationwide.
Nationwide,
Right.
that they can approach in case they want trademark
Yes.
registration. But once they encounter problems, I mean, an applicant is not without remedies, right? I mean,
Yes.
if, for example, I want to register a particular brand, I find out it's already registered. Well, what can I do? What can I expect my lawyer to advise me? You know, if I want to register that mark and it's already registered ahead of me.
Like as mentioned earlier by Attorney Ross, one of the remedies is cancellation that can be availed by the true owner of a mark. Let's say somebody fraudulently registered that mark and he was able to obtain a certificate of registration. Then the true owner of that mark can file for cancellation with the Bureau of Legal Affairs
Of the IPO.
of the IPO.
It's either cancellation or also if there's infringement, you bring the suit to court. You have to bring the suit to court. So anyway, we have only 5 minutes left. If you have any messages that we'd like to bring into our home viewers, especially those registering on January 15 for their business name and renewal, do register for your trademarks with the Intellectual Property Office. And as I said, we have here tonight the Division Chief of the Bureau of Trademarks and a senior trademark examiner who have given you tips on how to choose your brand and what to expect with the registration process and how long it takes, what grounds, you know, the possibility of getting rejected are, and whether or not you need legal assistance. Now, Attorney Jesan, I mean, what message do you have for our televiewers?
Well, to our dear televiewers, we strongly encourage you to register your trademarks. Your trademarks are very valuable assets of your business. So register them before it's too late. So it's never too late. Come to our office. We will gladly welcome you in Makati.
Attorney Jen, what are the contact details of the Intellectual Property Office that they can seek out?
Well, yes, you can log on to our website, IPOPHL.gov.ph, and then you can contact our office through phone. It's 238-6300. And you can ask for any examiner or the information officers, and you can ask anything about trademark application.
To assist you. All right. The Intellectual Property Office is also on Facebook. Do like them. It's IP Philippines. That's their ID. And we have more efforts on protecting trademarks, patents, and other intellectual property that's all around us. Next week, we will be having the arbitrators of the Intellectual Property Office to tell you more about their efforts in declogging their case dockets when it comes to intellectual property cases. Alam niyo po, minsan yung kopyahan, yun talaga yung malaking problema sa intellectual property, and that's when litigation comes on. So we need to educate ourselves so that we know more about our property and how to protect it. Again, I'm Sara Jane Suguitan, and you're here on Intellectual Property. Do join us again next week for another informative session on intellectual property. Thank you and happy weekend.